I'm Sean Hodge with Hodge & Green Law Firm.
And I'm Dennis Green with the Hodge & Green Law Firm.
We're here to talk to you and answer some questions about insurance policies and your claim. So you need to know your timelines and deadlines when it comes to reporting the claim. That's filing your initial claim with the insurance company. Historically, in Florida, you had 3 years from the date of loss to file your claim, but Dennis, those have changed with some revisions in 21 and then the new law that took effect just recently.
Recently, with the new laws that have been enacted, we've seen where these time periods have been reduced from session to session. So each legislative session, it seems like they've gone from 3 years to 2 years, and now it's 1 year for your initial claim.
Yeah, and I think it's really important because if you Google it, you'll see a lot of law firm websites that still have the old law, the old timelines listed on their website. And so it's one of those things where it started off at 3 years, it was changed and modified down to 2 years. Now under the new law, it's down to 1 year. And so I think the important thing for the insured to know, for the homeowner to know, is that you need to file your claim as soon as possible, right? The timelines are subject to change. If you have damage, if the hurricane impacted you, you saw any leaks, you saw any evidence of shingles that were torn or blown off, or you saw leaks occurring in the house, you saw any evidence at all that you may have had damage, you need to go ahead and file your claim now. Get it on file as soon as you can.
Yeah, Sean, most policies have a prompt reporting clause in the contract, and we're actually seeing a lot of carriers now that are denying claims for what they call late reporting. So if you fail to make that initial report, especially within the first 60 days, you're really creating a presumption that there was no valid claim at that time. That's why it's so important to make that initial claim within those first 60 days, so that way the insurance company's just not going to come out and give you a blanket denial.
Right. It's really like, at a wedding, speak now or forever hold your peace. Does anybody have any objections, right? If you know you have some damage, the time to file it is now, because you may have covered damage, but if you wait 2-3 years down the road, even though that was covered damage under your policy, it could be denied just because you waited too long to file it initially.
Sean, ultimately, the deadline for reporting your claim is all dependent upon the clauses in your own policy, and that's why it's really important that you seek the advice of a professional to evaluate your situation and exactly what's contained in your policy. Most attorneys will review your policy for free and give you some kind of a policy determination to let you know exactly what those rights are.
So, statute of limitations is generally the timeline you have to bring a legal action. If you don't like the outcome of your claim, you don't think the insurance company correctly paid your claim, they denied it or they underpaid it, and you believe you're owed more money, there are certain timelines and deadlines to actually bring that lawsuit and initiate the legal process. So that's what statute of limitations is, your timeline to actually bring your case in court.
The statute of limitations can also be shortened by the specific language in your policy. That's why it's important to check to see what your statute of limitations is.
Insurance policies are very complicated. Now the average policy is hundreds of pages long. There's a lot of exclusionary language, different caveats and loopholes for the insurance company. You need to make sure that you have a professional review your policy so they can explain it to you, tell you what coverages are available, how much money you may be owed. So you need to consult with a public adjuster or an attorney, somebody that specializes in reviewing insurance policies.